Hello, good afternoon, and welcome to The Law. This is your legal light. It is your health law, and I'm your host, Samson Lardy Anyenini. A few weeks ago, we came your way with prosecutorial errors, getting the poor into jail. And by popular demand, we are bringing you part 2 of that with a lawyer and a prolific author of legal texts in criminal law. We'll be right back. Thank you very much. Thank you for joining us wherever you are joining us from. And my guest is the lawyer Daniel Korang, who is a lawyer and author. He's with Adom Legal Consult. It's a law firm based in Sunyani. And we have had raving reviews from some of you about his contribution on Newsfile yesterday. So, because of some of the comments that we have received from you, we will not start straight away by going into the issue of prosecutorial errors. There was an issue that we have him help us discuss yesterday that many of you have some questions about. So we're going to ask him to help us explain that area of the law a bit before we go into prosecutorial errors. And because this matter is at the front pages of your minds because of the case that has just been concluded in respect of the Capital Bank matter. Daniel, thank you so very much for making the time to join us once again.
Thank you for having me.
Right. So, by our Law 101, we want you to assist us to better understand the law in respect of Section 35 of the Courts Act. And I will just read few portions and get him to explain. That has become a very popular law in Ghana because of what has happened, where somebody is paying money and then getting out free without going to jail, and many people cannot just understand how that happens. So Section 35 of the Courts Act 1993 says offer of compensation or restitution. Where a person is charged with an offense before the High Court or a regional tribunal, the commission of which has caused economic loss. And people remember that you were emphasizing that portion on Newsfile yesterday. Has caused economic loss, harm or damage to the state or any state agency. The accused may inform the prosecutor whether the accused admits the offense and is willing to offer compensation or make restitution and reparation for the loss, harm, or damage caused. Where an accused makes an offer of compensation or restitution and reparation, the prosecutor shall consider if the offer is acceptable to the prosecution. If the offer is not acceptable to the prosecution, the case before the court shall proceed. If the offer is acceptable to the prosecution, the prosecutor shall, in the presence of the accused, inform the court, which shall consider if the offer of compensation or restitution and reparation is satisfactory. Where the court considers the offer to be satisfactory, the court shall accept a plea of guilty from the accused and convict the accused on his own plea, and in lieu of passing sentence on the accused, make an order for the accused to pay compensation or make restitution and reparation. An order of the court under subsection 5, and that's what I just read, shall be subject to such conditions as the court may direct. And finally, where a person convicted under this section defaults in the payment of any money required of the person under this section or fails to fulfill any condition imposed by the court under subsection 6, any amount outstanding shall become due and payable, and upon failure to make the payment, the court shall proceed to pass a custodial sentence on the accused. This is the now famous Section 35 of the Courts Act, because of which Ato Asian is not in jail. Yeah. How do you explain? Because many don't understand. How can it happen that you pay money and get away? And they say this is encouraging crime, rather.
Very well, thank you, and good afternoon to our viewers. Let me begin by saying that there are many types of criminal offenses in Ghana. Many types of criminal offenses in Ghana. Now, let me, for the purpose of the present discussion, talk about stealing, which many people think is now the trending offense. Now, there are various types of stealing. Somebody might steal a thing belonging to an individual, so that I park my car somewhere and somebody steals it. Or somebody breaks into my house and steals my laptop or anything, any valuable belonging to me. That is stealing a thing belonging to an individual. Then somebody might steal a thing belonging to the government of Ghana, which could be a property, whether landed or movable. Or it could be money, like Ato Esen's case. Now, you realize that this is a criminal offense of stealing. But this stealing is stealing of public funds or public money. So clearly, you realize that when somebody steals money belonging to a community bank, there is a loss to that community bank, but not a loss to Ghana as a country. Now, when somebody steals money belonging to the public, like Ato Esen's case, the loss caused is to the public or the Republic of Ghana. And so it makes the case a special one, in the sense that we are not talking about an offense to any individual entity. So now when the offense has caused financial loss to Ghana, what this provision is saying is that when the person is arraigned before the court, and it is clear that this offense contains an element of loss to the government, that accused person might suggest to the prosecution that, Charlie, I see that the offense I am being charged with is one involving a loss to the government or to the state. And so I am willing to return the allegedly stolen money to the government. So when that willingness is expressed, the prosecutor may say that, well, let's go into a bargain or some sort of agreement. How much are you restoring? Then he said, I'm restoring the entire amount that I am alleged to have stolen. If the prosecutor agrees, if the prosecutor finds that this agreement is reasonable and fair in the interest of the state, then it is a duty of the prosecutor now to bring this to the attention of the court or to the notice of the court.
But it's not about just refunding, because it talks about reparation, restitution, or compensation, right?
Very well, if I may explain that. Now, if the accused says that I am refunding the amount that I have stolen, assuming that the amount is 20 million Ghana cedis, I am refunding 20 million Ghana cedis, plus, say, 10 million as compensation to the government. You know, we know that in ordinary terms of economics, when you take somebody's money for some considerable, period of time,
right,
the person is entitled to some interest on the amount that you have withheld or taken.
That's right.
And so let's assume that this loss was caused to the government 3 to 4 years ago. And so I want to refund the money first and then give some additional amount as compensation or interest to the government. Now, when the Attorney General finds this to be prudent and reasonable, the Attorney General brings this to the attention of the court. Then the court also has a discretion to say that, yes, the Attorney General has agreed with the accused, but I, the judge, will not agree because I find this not to be in the interest of the state.
Right.
The court has the discretion to exercise. But where the judge has that or finds that it is reasonable bargain, the judge will agree that, yes, I feel that this is a reasonable bargain in the interest of the state. Now, let me put this across, that when judges sit to determine cases, especially those involving, national interest, it is the duty of the judge to ensure that that national interest element is adequately protected and safeguarded.
Right.
And so a judge cannot agree or accept a bargain which is not reasonable in the interest of the state.
Right.
Now, when the judge agrees, the judge will now tell the accused person that once you have agreed to refund the money, do reparation, compensation, and restitution, I am going to proceed to let you plead guilty. Because by this agreement, the accused is saying that I am guilty of the offense.
Right.
And so he goes ahead to plead guilty. And upon plea of guilty, the judge will convict him on his own plea. But instead of sentencing him according to law, you know, sometimes when you steal, stealing is a second-degree felony. And that mandatorily involves custodial sentence. Now, the public should know that when you steal in Ghana, you cannot be fined to go home. Stealing is a second-degree felony, and under the procedure, it involves mandatory custodial sentence. That means that you will be imprisoned. Now, instead of the judge imprisoning the accused person, the judge tells him to refund the money, do all necessary compensation, reparation, restitution in terms of the concluded agreement, so that he will spare him custodial sentence.
Right.
Now, it is not because this judge is giving a special dispensation to this accused person, but the procedure under Section 35 is that any person who opts to be treated under this section will be spared custodial sentence.
Okay, so let's get a few basics correct. Once a person has been accused of an offense, which is a criminal offense.
Yes.
And the offense involves economic loss to the state. When that person is put before the court, that person, according to Section 35 of the Courts Act, 1993, has the right or the opportunity to inform the prosecution, in this case, Attorney General, or it could be the police who are doing it, that by this law, I am allowed to make an offer to make a refund, make restitution, reparation, and compensation. Please look up those words, restitution, reparation. They are what they are. Then, as you say, once the offense has caused economic loss to the state, or harm or damage to the state, then it qualifies.
It qualifies.
If it is not an offense that causes economic loss or harm or damage to the state, it's not qualified.
That's not.
But once these things are present, it doesn't matter who you are as an accused person.
That's it.
You are entitled to approach the prosecution and suggest to them that you want to do what? Use Section 35.
Yes.
And you say, once you approach them, as the law says, then they will sit down with you. And if they agree to what you are offering, or they may ask you what they want. They say, you want to, maybe it is 1,000 cedis, and you are refunding the 1,000 cedis. They will say, we will not accept you refunding just 1,000 cedis. You refund the 1,000 cedis, then you make compensation of maybe 10,000 reparation and restitution or of some sort. Then you do that. Then there will be an agreement that is signed between you and the attorney or the prosecution. Then they will move to the court, inform the court in the presence of the accused person, as is said in the law, that this is what we have agreed. We accept it. Or in fact, they wanted to give us just 1,000. We said we won't accept. We'll take 1,000 and 10,000 plus this plus that. You see, it is now left to the judge to also consider if what they have agreed is satisfactory, as the law says.
As the law says.
Once the judge considers that it is satisfactory, then the judge is bound to ask you to plead guilty to the offense. So you'll be asked, are you guilty of the offense or you are not? And you say, I'm guilty.
I'm guilty.
Once you say you are guilty, in the situation where you should have gone to jail, the judge cannot.
Mandatorily.
Cannot.
Not
at all.
That will not, but cannot. You see, it's a regime. It is a procedural regime. So that when we proceed under Section 35,
right,
and the agreement is brought before the judge, and the judge thinks that I have looked at the offense, I have looked at the facts, I feel that in the interest of the state, the agreement is satisfactory.
Yeah.
The judge cannot say, I am accepting the terms of the agreement and also imprison you.
Okay.
That is not allowed.
So Section 35(5)
Yes.
says, where the court considers the offer to be satisfactory, the court shall,
which is mandatory.
okay, accept a plea of guilty from the accused and convict the accused on his own plea, and in lieu of passing sentence on the accused, make an order for the accused to pay compensation or make restitution and reparation.
That's it. You see, let me explain a bit of that subsection.
Okay.
You see, we call something sentencing,
Right.
which is part of a criminal trial. Now, sentencing means that after the accused has pleaded guilty or has been found guilty or has been found not guilty, the judge will pronounce a sentence on him. And the sentence where there is a guilty plea or a finding of guilty will be to go to prison or to be fined or whatever.
Right.
Now, here, the judge doesn't pass sentence. That is why it says that, and in lieu of sentence. In lieu of sentence means that in place of sentencing the accused person,
Or instead of sentencing
him, the judge will say that, well, go ahead and make your payments in terms of the agreement. So what happens here? There is a suspension of what? Sentence. The public should understand this. That we are not saying that the judge has left this man to go scot-free.
Right.
But the judge has temporarily suspended sentence.
Okay, now let's continue from there. It says it will, instead of passing a sentence
Yes.
on the accused, make an order for the accused to pay compensation or make restitution and reparation.
Yes.
Restitution, according to my dictionary, is the restoration of something lost or stolen to its proper owner.
That's it.
Restoring something lost
Yes.
to the owner,
That's
the proper owner.
Yes.
Then reparation, the action of making amends for a wrong one has done by providing payment or other assistance to those who have been wronged.
That is it. That is it. So in clear terms, reparation is bigger than compensation and restitution. Restitution, as you said, means I am returning what I have stolen
To the proper owner.
the proper owner. So if, let's say, Atu Essien stole 90 million Ghana cedis, he returns that 90 million Ghana cedis, and that is restitution.
Okay.
So in Latin, we say restitutio in integrum.
Right.
That is the Latin version
That is
of
right.
it.
Right.
Now, that is restitution. Compensation means that,
Or reparation.
let me mention the compensation.
Yeah.
Compensation means that having done restitution, having returned the stolen amount, I am adding something.
Okay.
Because, you know, when you steal somebody's money, you deprive the person of use of that money.
Yes.
And possession of that money.
Maybe you took it and you kept it for about 1 month.
Or 2
Within
years.
the 1 month, you could have used it to
That's it.
also make some.
And so that is where the compensation element comes in.
Okay. Okay. And reparation could involve making financial reparation to a victim.
That's it.
Right.
You know, they may be used interchangeably.
Interchangeably.
Reparation and compensation.
Okay.
So now, when this is done, the purpose of reparation, compensation, restitution is to return the original owner of the stolen item to such position that he would have been if the stealing had not occurred.
So that's restoring
The person.
Okay.
And I think the element of compensation is even intended to make the person's situation better off.
All right.
You understand?
Right. So, and we are not focusing on the case that has happened, but we are using that development to explain.
Yes.
So in this case, we are told that the amount that in fact was owed was 57 million.
Ghana cedis, yes.
So there is 32 million, which is reparation or restitution or compensation.
Yes.
Because he has paid he has agreed to pay the full amount, which
Yes.
is 57.5 million.
Yes.
And then the 32 million will be the sort of the compensation or reparation.
Yes, that's it.
Okay. Now, I'm coming to the question that many say, this will encourage crime. I can take money if I've stolen money.
Yes.
In this case, in his case, we are told that it is what was said to be money for business promotion.
Yes.
But the law calls it stolen. Now, what has happened? You don't agree with members of the public who say that this actually encourages crime. It does not discourage crime.
Well, my thinking is that it may encourage crime, it may not. And let me explain both. Now, people are thinking that yesterday, if you clearly listen to some of the contributors, some were comparing crimes dealt with under Section 35 to stealing goods, stealing plantain and all that. Please, when you steal plantain, you cannot come under this section because that stealing does not contain an element of causing financial loss. Economic loss to the government.
All right.
So when you are in the Western region and you enter somebody's plantain farm or cocoa farm and pick some quantity of, raw cocoa nuts from the person's farm, you cannot plead under this section.
Okay.
Because we will ask you a simple question. Has there been a loss to somebody by virtue of your crime? Yes. Who suffers that loss? Is the cocoa farmer and not the government.
And I think one overriding thing too is qualification is here. The crime must be a crime that is being prosecuted in the high court
or the public
regional tribunal.
Okay. So that when you are being dealt with in the district court, this is a very important one.
Or in the circuit court, it's not qualified. Yeah.
So what it means is that even when your crime involves economic loss to the state, and you are being dealt with in the district court, you don't qualify.
That's right.
Or in the circuit court, you wouldn't qualify.
Okay.
And so we should get the elements for qualification very clearly. Now, when that person says that, and there's an important thing, he said that, and the accused is willing to offer compensation.
Yeah.
You see, it is not every accused person who might be willing to offer compensation. So that we have a situation.
In fact, you must first admit the offense.
Yes.
And be willing to offer compensation or make restitution and reparation for the loss, harm, or damage caused.
That is it. We have been aware of cases in Ghana where people were charged with causing financial loss to the state. They were convicted and thrown into jail. And as we speak, we have no idea whether they have even done reparation or restitution. So that when you are convicted, you might say that, well, I have been convicted, but wherever I'm hiding my booty, let it be there. After my jail term, I'll come back and enjoy it. Or even if I'm going to spend the entire life in prison, my family should take it. There is unwillingness to do restitution, even though the person has been found guilty.
So it's available to everyone or anyone who is accused of a crime of economic loss to the state, and who is being prosecuted in the high court or regional tribunal. Okay.
And who accepts or admits his guilt. Let me say something about this. When we go to the courts in criminal cases, admission of guilt is seen as very important.
Right.
And the court will always consider that as a mitigating factor, even in punishing you.
Sentence.
You know, when somebody admits guilt, they spare the court, prosecution witnesses, the ordeal of having to go through a full trial. You know, full trial it comes with some drudgery, you know. You have to go through the drudgery of...
But the law says you can do this thing any time before judgment.
Any time before judgment. So even when you see that your conviction or your guilt is looming, when it is imminent, it is just coming at you, you can take advantage of this.
But we are told of circumstances where people choose this, even though they don't feel that they are in fact guilty.
Well, you see, criminal law is a bit technical. you can take property not belonging to you, but that might not be stealing. Do you know that when you make misappropriation, it can cause financial loss to the state?
That's right.
But that might not be stealing. So the government can entrust property or money into your hands, and you might misappropriate it.
Use it for something else other than the purpose.
Yes.
And you will still be guilty of some offense.
Yes.
You haven't used it for yourself.
For yourself.
Okay.
So when you misapply funds, we will tell you that you have caused financial loss, but clearly this might not amount to stealing.
All right.
We know in criminal law that there are two basic elements of criminal liability. What is said in Latin, actus reus, the physical element, which means that you are physically involved in doing something.
The fact that you have taken the thing.
Taking the thing. And then the mens rea. The mens rea means the mental element.
You took it, but we want to know if, in fact, in your mind,
you had a guilty mind,
intention to
take,
to steal.
So it is not everybody who takes money in fact who can be said to be guilty in mind. You see,
it's not everybody who causes the death of somebody actually intended to cause their death. So the actus reus, we can see that he took a gun and shot, or he took an instrument and caused the harm.
That's it.
But we may find out and discover that in his mind, he didn't have an intention to harm.
So in my criminal law class, what I usually tell my students is that when I'm explaining this, I tell them that crime is divided into two: physical element and mental element. The physical element is the fact that you are physically involved in doing the prohibited act. Now the mental element is that your mind must follow your physical act, or your act must follow your mind. What it means is that there must be concurrence of physical act and guilty mind.
Thank you very much.
You understand that linkage?
So that explains why a child of not more than 12 years can do something which causes harm but has not committed a crime, because the law presumes them not to have the capacity or mind to do wrong.
That's it.
Okay.
No, the dole incapax.
That's right.
That's the Latin version.
Right.
What it means is that a child below 12 years is incapable of forming guilty mind, because their minds have not formed enough to distinguish right from wrong. And so when we are discussing stealing like this,
so we say everyone intends the consequences of the actions they take.
That's this.
But a child will not intend the consequence of the actions
or an
they
insane
take.
person.
Right.
Or even in some circumstances, an intoxicated person.
That's right.
Because that the drink or the alcohol has worked on your mind and has deprived you of the capacity of thinking right.
Because you are drunk.
You are drunk. So mental element in crime is really important.
Okay, so that was a bit of a departure, but I suppose it was very good to explain to you how lawyers, courts, the law itself considers issues of crime and thinks about crime. Now, the very final part.
Yes.
It says, where a person convicted under this section defaults in the payment of any money required of the person under this section, or fails to fulfill any condition imposed by the court under subsection 6, any amount outstanding shall become due and payable, and upon failure to make the payment, the court shall proceed to pass a custodial sentence on the accused.
Now, my understanding of this very provision is that, I mentioned that yesterday, that when a person is tried under section 35 and the agreement is concluded and the judge accepts it to be satisfactory, the fact that
they escape jail.
And they escape jail. The fact that they are escaping jail doesn't mean that the trial has come to an end. It is held in abeyance. In abeyance means that now that you have agreed to pay, we are allowing you to go home, take steps to pay. But, I mean, and within reasonable time, within a specified time.
Yes.
The judge can say pay, or the agreement can say I'm going to pay in 5 months. Now, if in 5 months you have not paid, that is a default. When you default, you will be brought back to the court, and now the judge is going to pass that suspended sentence on you. You see, I mentioned that when you are going to escape jail, it is just a suspension of your sentence. So when you default, that suspended sentence now descends on you. It comes to you.
Until you have finished fulfilling the conditions
of the
for Section 35, as in the agreement,
yes,
you are still a candidate to suffer sentence.
Criminal sentence.
Custodia.
Custodia. And here you cannot be fined. You look at it, you cannot be fined.
Okay.
So when you fail or default in making the reparation in terms of the agreement, you will be brought back and you will be sentenced to jail. And so no accused person who is made to go home under Section 35 should go thinking that he has escaped. You have not escaped.
Okay.
You have been given a temporary relief or respite, kind of. So when you go home, you take steps to make the reparation. And you know, let me talk about the philosophy behind this section. I mentioned that yesterday, but for want of time, I could not explain. Now, when somebody has caused financial loss or economic loss to the state, and the person wants to do reparation, we shouldn't think that the money is sitting somewhere for him to go and bring. Economic loss may be restored by going through economic activities. So I have caused economic loss to the government, and I have to do reparation, restitution, and compensation. How do I do that? I have to now maybe engage in some fruitful economic venture, or go about asking for loan or whatever to come and do the restitution. So the philosophy is that a person in handcuff, a person incarcerated, cannot engage in any fruitful economic activity to make reparation and restitution. And so we allow this person to go home to put his house in order just so he can pay the money.
And there's been the attempt to make the point that the conviction itself is punishment. So people should not think that once you come under this act, this law, and you go without going to prison, you have not suffered, you have not suffered. What is punishment with conviction? I've been convicted. What's the punishment about it? Or the fact that I'll be called an ex-convict? What's about it?
Let me explain first that in our criminal jurisprudence, imprisonment is one of the many recognized punishments that we know. Somebody might suffer death, that is punishment in Ghana. Imprisonment, punishment in Ghana. Fine, money paid to the government, that is punishment in Ghana. Probation is punishment in Ghana. The court might order that you be under police supervision for a specified period of time. That is punishment in Ghana. The court might order that you should be made to sign a bond to be of good behavior and
for a certain period.
Yes, and to keep maybe the public peace. That is punishment in Ghana. So we have various forms of criminal punishment. But it appears that the public are focused on imprisonment, which we think is a traditional way of punishing somebody. Now, how can conviction alone be said to be punishment? Yesterday, the Deputy Attorney General, Fred explained that when you are convicted of a criminal offense, you become a criminal. And when you are a criminal, then it means that there are certain things that you might not have the right, again, to do, like being a parliamentarian, being a president of Ghana or vice president, or holding certain key positions. And this deprivation is...
And in this particular case that we're using, the Capital Bank case,
yes,
by the Special Banks and Specialized Deposit-Taking Institutions Act,
yes,
when you suffer a conviction, like has happened to Atuesian,
yes,
you cannot be a director of a bank anymore.
If this is not punishment, what else can it be called? It is punishment. And so we should have a basic understanding.
Some people can't get jobs once they have suffered a conviction.
Yes, it follows you.
Some employers don't, they will ask you, let's have your criminal record. Have you ever been convicted?
It is a
And
stigma.
some people ask you to go to the police to get
A report.
a criminal record, a
Yes.
report to show whether you have had a
In
conviction.
fact, you cannot even go to law school.
Yes.
If you have
You can't be a lawyer.
a record of conviction, you can't be a lawyer in Ghana.
On dishonesty.
Dishonesty.
Okay.
When you are applying to go to law school, they will ask you for all this clearance. And for me, I think that what matters is what has been done. So the public should understand it.
The law 101 has turned into the actual discussion for today. But we understand because as we talk, I can see the messages that you are sending in because this is an issue that is hot. We'll take a quick break. When we come back, I will still ask you one more question on this because when it happened, I brought up an issue about the Plea Bargaining Act.
Yes.
And I asked, why didn't the state use that one? Because that one, for example, gives opportunity for where it says you have an agreement to reduce the offense charged to a lesser offense included in the offense charged.
Yes.
Withdraw the charge against the accused person. Withdraw one or more of the charges against the accused person, or promise not to proceed with the charges against the accused person. Then the person will still pay money.
Yes.
So in this case, you can have a plea bargain where an offender refunds, makes restitution or reparation, and then still goes to jail for a short time at least.
Yes.
We'll be right back.
All right.
Yo, welcome back. This is The Law. It is your legal light. It is your health law. And our guest is the man that by your popular demand, we have brought him back. Daniel Krang. He is a lawyer and he's author, and I keep saying prolific author of legal texts in criminal law. And I mean that when I say so. He works from the Adom Legal Consult. It's a law firm in Sunyani. And when I say prolific author, this is what I mean. This is one that is a textbook on criminal law in Ghana. This is number 2. This is what I'm very familiar with, and I have used it to improve my pocket and my economic circumstances. Of course, help my clients first. Criminal Prosecution in Ghana, Practice and Procedure by the same man. This is Jury Trial in Ghana, Exposition and Critique by him. Then you have... oh, these are not all. You didn't bring all of them. No. And this is Preparing for Law School, a Practical Guide. Preparing for Law School, a Practical Guide. And this is How to Study the Law by him. Before we are done, I will tell you the other criminal law books that he's worked on. So I asked the question, and we have actually opened the phone lines. Well, yes. We're showing some of them on the screen. Right. And then... what was I going to say? That whilst you're going to try to explain what I had asked earlier, people, you are free to call now, ask him any question about this area. In fact, if you ask him anything about criminal law, he will explain. But we are not going to do that today. He's talking about what we have just started discussing. Right. Okay. So why couldn't we have used that other law where you are made to pay, you don't go to jail, you are made to pay, you make reparation, you make restitution, and then you still go to jail for a lesser time, small at least.
Yes. Well, I said yesterday that within the broad criminal procedure, we have a lot of regimes or arrangements within, so that when a person is accused of a crime, the person might be tried just as every criminal trial happens, without any opportunity to undertake any agreement or go through any agreement. You are being tried. When you are found guilty, you are sentenced, that's all. And maybe consequential orders for reparation may be made. Another approach is that you will be brought under the now Plea Bargaining Act, which allows that you would make reparation, you might be given reduced punishment, by way of imprisonment.
Yes. It says a person charged with a criminal offense may at any time before judgment negotiate with the prosecutor for an agreement to A, reduce the offense charge to a lesser offense included in the offense charge, withdraw the charge, so they can withdraw the charge against you. Withdraw one or more of the charges against the person, or promise not to proceed with the charges against the person. What would the state get in exchange for all of this? Like withdrawing the charge, getting a lesser charge, or withdrawing some of the charges, withdrawing all of the charges, or making a promise not to prosecute you. What would the state gain from that?
Now, the emerging practice in developed legal systems is what we call restorative justice. When we say restorative justice, it means that we are allowing accused persons to meet with the victims of their crimes so that they restore them. Restorative justice is very prominent now. So the opportunity to restore means that we are focusing now on the victim and the harm caused and how to remedy it. We have done imprisonment for decades, and we have realized that it does not really help. And so we are now trending towards restorative justice, allowing the criminal to restore the victim.
Right.
So whether it's a state or an individual victim, we tell them, Charlie, the opportunity is there for you. Would you want to restore? So when you come under the Plea Bargaining Act, the Attorney General will enter into negotiation with the accused person and say that if you agree to do ABC to restore, we may withdraw some of the charges or even all of them.
Or you can agree to be a witness for the state.
Exactly.
So that you go and testify against
other accused persons.
A larger group of people who are into that crime, but we cannot find them, but you can help us to find them.
Provide information.
Good. So we will not prosecute you.
Yes.
So that you lead us to all the other.
So you can get a bigger,
okay.
fishes.
Now, there are guys on the phone. Moshood, you are calling us from Tamale, and Godin, you are calling us from Saliga. Let's pick Moshood first. Hello.
Hello.
Yes, go ahead. Ask your question.
Okay. My question, in the case of Atuforsen, the court has agreed for him to pay in installment. So if he paid the first installment and maybe default in the other installment and the time elapsed, what will happen?
Thank you very much. Godin from Saliga, what's your question? Hello, Godin. Is it Gordon or Godin? Hi, Gordon from Saliga. We have lost you. What will happen? You have been given a time to pay back. You pay some, you don't finish, and then the timelines you default. What will happen?
Now, in default of agreements like this, we have partial defaults, we have complete defaults. If the agreement is that within 1 year, you are going to make 3 installmental payments. First 3 months, you pay this amount. 6 months, you pay this. And the 9th month, you pay this. When you pay the first one and you default in paying the second one, it is a default. So if the Attorney General doesn't have patience and they say that we are going to enforce it, they can enforce it.
Okay.
But they may as well say that, well, we gave you 1 year.
And the enforcement means what?
Enforcement means they are bringing you back to the court.
So that you'll be put to jail.
You put to jail.
Okay.
Or they may wait for the 9 months to come.
Okay.
So that when you are unable to pay, they bring you back to the
Sylvester, you're calling from Techiman. Techiman, you may be familiar with Daniel. Let's hear you.
Yeah, I want to know if the convict keep the money.
If the what?
The convict pays the money. How will the public know that he has paid the money to the state?
Oh, okay. Thank you. Daniel, you are calling from Babiani. Hey, okay. So people are...
Okay, for Samson, my question is, if somebody steals plantain, for instance, would the person be allowed to go and plant plantain in 6 months and then give it to the person they have stolen it from? Since if you are rich...
All right, you didn't join us from the start. Thank you very much. You didn't join us from the start, but still answer the first one. How do we know that the person has paid the money back to the state?
Now, let me mention that criminal trial is a public event. even though it happens in the confinement of the courtroom. It is a public event. Anybody can go there to listen. Otherwise, just like this one, that involves a lot of public interest. The media were there.
Or you can file an RTI request.
Yes, the media men and women were there to publish. So if Atu-Forcing pays by the end of next year, Atu-Asian, sorry, there's an Atu-Forcing.
Yes, there's an Atu-Forcing, yeah. One of the questioners say Atu-Forcing.
Yes, yes. When he pays, I'm sure we are going to hear of it. Or if you want to know, you can file
RTI request
information, then they'll give it to you.
Okay.
And somebody asked whether a plantain thief will be made to plant plantain. What we are saying is that this arrangement occurs only in offenses that involves economic loss to the state.
To the state.
Not to
and offenses that are being tried in the High Court.
In the High Court.
Collins, you are calling from Tema. Let's hear you.
Yes, my question is, we have a civil and criminal case.
That's right.
This one, the person has accepted stealing the money. That one becomes criminal. And the civil is where we should take the money. But I don't understand why he's only paying the money without going to jail. Thank you.
Okay, so you simply don't understand. The explanation has already been given. Thank you very much. Yes, who else do we have? Okay, John. Hello, John. Hello, John.
Yes, sir.
Go ahead with your question.
Yeah, my question is that the person is charged before court. And how can the person went to negotiating table for them to reduce or change the charge against...
Because the law allows it.
Yes. That is my question.
Yes, because the law allows it.
The law allows it.
Yes, Section 35 of the Courts Act, 1993.
Okay.
All right. Thank you. Time runs so fast. So can you see something? I don't take it that the person who called before John and John, they didn't listen. I take it that they listened, but they still can't take it. That why should it be like that?
I said something yesterday, and being a lawyer, all of us are very aware of that. That law sometimes is not logic. It's not logic because it might not make sense to the ordinary person. And I would say that in great majority of cases, the law is not supposed to make that sense to people. When parliamentarians are making laws, we have a memorandum that follows it. It's an explanatory note.
That's right.
They will explain all these things. Listen, when somebody goes to jail for life and keeps the money that he has stolen, of what benefit is that to us? The person is rotting in jail, and the money he has stolen is lost forever. That is why we are now emphasizing restorative justice, restoring people to their previous or better conditions.
I've had people ask the question. They say, for example, like Kofi Bentel asked the question.
Yes.
We have prosecuted people for huge sums of money.
Yes.
And put them in jail. That's it. We haven't gotten one CD or one peso for them. One of them is a recent NCA case.
Yes.
Where I think it was about $4 million that was involved. The people have been put into jail. Where's the money?
No amount has been refunded.
But you want criminal sanction to be deterrent. So put them in jail. So everybody will see that this thing tomorrow, don't go and do it. Because if you do, you go to jail.
That's it. Well, I think that if the law permits that something be done, we will do it.
Okay.
But just as you said, you answered somebody. If the law says that you can do a particular thing, it's a matter of applying it and doing it. So the accused person says, I want to be treated under Section 35. And so be it.
Right.
You know that this current plea bargaining law, many people haven't got to understand it. Now, if they get to know what it says, they might even challenge it.
You had the privilege to be part of the process of consultation to make that law.
Yes.
So you have a better understanding. So if somebody doesn't understand it, they have the right not to understand.
Well, that is why, you see, I'm writing a book.
Okay.
I'm currently writing a book that will educate the public on some of these basic things. I'm not writing the book for lawyers per se, but for the public. And when it is ready, I'll let you know. so that the public will get it and then they'll be educated.
And you see, there's one thing. If you have heard me, I've used this platform. We have used this platform here to try to educate people about these laws, plea bargain. Dana Sunabadapa, the Deputy Attorney General, Deputy Minister for Justice, was here to explain it, at length to people. I have also sought to actually advocate the community sentencing law, which is the poor man's plea bargaining. That is the law that somebody who is stealing plantain and things can also be found guilty and yet not taken to jail. They would rather be asked to go and maybe weed or go and do some other work and then go free.
For the benefit of the community.
Exactly. So we should do that as fast as possible. Otherwise, what we are doing on these laws is to benefit the rich people, and then the poor people continue to suffer.
I have always said that our sentencing regime in Ghana is archaic, is so antiquated. What it means is that we are following what used to be there in 1960. We have to, bring a revolution, change to our sentencing regime.
Right.
So we bring more beneficial, approaches of sentencing.
Our time is up already, and there are many people who are so excited about what you have done on our platform. A lawyer and friend, Frederick Samson, says that good education by Daniel, and then there's a psychologist at the University of Ghana, Dr. ABC. He says that good afternoon. Your guy, Krang, is really good. Ayiko. Thank you also very much for joining us, because the topic that we advertised was to continue part 2 of the prosecutorial errors that get people into jail. We have suspended sentence, plea bargain. We'll come and deal with it later, some other day. Thank you very much. Daniel Krang is a lawyer and is an author of legal texts, a prolific author at that, and he works from Adom Legal Consult in Sunyani. Thank you so very much. I'm so grateful. So grateful. Right. Okay, this is the law. It's your legal light. It's your help law. Have a good afternoon.